One of the questions I get, it puts pressure on the primary carrier to go ahead and settle within policy limits, usually $1 million primary limit. The question I'm getting now, Laura, is when we have umbrella towers, we have umbrella limits, let's say up to $20 million, and there's 5 or 6 different umbrella excess carriers over that primary $1 million limit. How does that work when you get a Stowert, well, I'm going to call it a hammer letter, when you have layers of excess carriers building up to the 20 million, how does that work?
So it can be fascinating, Ron, because what we're seeing right now is that plaintiffs' counsel feels so much pressure on them to get a demand out quickly that they actually aren't demanding a specific number. So sometimes they'll say, I'll settle your case if you give me $5 million. But more often than not, what we're seeing is they don't know what the insurance tower looks like. And so they say, I'll settle your case for policy limits. And what does that mean? Does that mean the million primary, or does it mean if you have a $10 million tower, are they looking for the full $10 million? And so the onus is on the primary layer to really thoughtfully respond to the case, disclose what their limits are, what might be remaining potentially, depending where you are, both in the country and in terms of litigation. But what you're trying to do ultimately is get plaintiffs' counsel to say a specific number that they are looking for. And then if it's in excess of the primary layer, they can only say either I'm rejecting the demand because it's excessive, or I can't accept the demand, but I can accept my portion of the demand. And then they would notify the excess carrier and potentially tender their limits. And that's where the concept of a hammer letter really comes into place, because the demand from plaintiffs' counsel is the Stowers or the Holt or the Tiger River, whatever machination it takes depending on your jurisdiction. But then the hammer could potentially come in if, let's say, we have a scenario where they want $2 million and the primary says it's definitely worth more than my million. So yes, I'm going to accept vis-a-vis my policy. And then let's say your excess carrier doesn't want to accept or is slow to accept. Either the insured themselves or the primary carrier could, quote, hammer the excess carrier. And what that looks like is sending a letter saying, we believe you should resolve this case in good faith within policy limits. And what happens for the excess carrier is if they have been hammered and they don't accept the demand, and then ultimately there's a verdict in excess of the $2 million, that excess carrier may potentially have to cover the verdict even if it's beyond policy limits. So let's say they don't take the $2 million, they've been hammered, and a $20 million judgment comes out, that excess carrier may potentially be on the hook for the full verdict.
Okay, so it incentivizes excess carriers to negotiate in good faith, but also incentive to go ahead and settle, because the potential of a big verdict going way beyond, say, their $2 million limit. And that's an issue. That's a really big advantage for plaintiff lawyers.
It is. And so one reason why I think they've become so popular lately is a book was written called Running with the Bulls, How to Win Top Dollar Settlements. And it was written by Nick Rowley, which is a famous plaintiff's attorney in California from the Rowley Law Firm. And he claims to have won $3.5 billion in judgments for his clients. And in this book, I won't buy the book because it's $185, and I refuse to give a plaintiff's lawyer $185 of my own dollars. But I understand he suggests that it's essentially malpractice if, as a plaintiff's lawyer, you don't make a time limit demand at some point in the case. So that's why you see these demands kind of frenetically coming out in almost every single case is, oh, I have an obligation to my client, I better put out a time limit demand. But in reality, there's only so much time in the day, and these letters have to be responded to. And so sending out letters for insane values that you yourself never are looking for in the case just ties up adjuster time that could actually be spent evaluating your case and making a reasonable settlement offer. So I personally think these time limit demands have utility, but are bad for the industry and can at times slow up resolution rather than facilitating it.
When we're thinking here, with the umbrella market being very tight, I mean, there's limited amount of capacity to insure a heavy construction account. And if you have a $20 million umbrella sitting on top of your $1 million primary GL limit, you may have 5 or 6 different insurance companies that's building up that $20 million tower. So with Stowers, I would say that would be a crazy trying to manage 5 different opinions on the strategy on how to settle a case or not settle a case.
It can get problematic. Oftentimes you can see the exposure is de minimis and it should settle within the primary. Or I think this is a $5 million case, so the primary puts up their limit and the first layer excess puts up their limit. But where I think it gets significantly harder is in that $15 to $25 million range. I think there's a lot of subjectivity there around fatalities with people of a certain age. Do you think it's more on the low end? Do you think it's more on the high end? And that's where I think you tend to see a lot of valuation disputes, is really trying to hone in on the worth of those claims.
Yeah. Gene, you've been Stowered before on a couple of your clients.
Well, and it's unpopular for the client, the insured as well, because the sentiment from them is fight, 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 fight. Like we want the carrier to get after them. But when there's infighting between the umbrella carriers on valuation disputes and these types of things, or maybe a hammer letter coming from a higher level carrier down to a lower level carrier, that might cause the carrier to want to settle or go ahead and accept the demand. And then, you and I have to deliver the bad news. Yeah, it's unpopular. The insurance carrier gets the blame, but the statute and how it's being used is really the breeding ground for all of the consternation, right? And so, yeah, I mean, it can be very frustrating on this side of the table. I know it is for them, for sure, but what do we say? It's like taking a butter knife to a gunfight, right? When you're trying to deal with all of this and align the defense and align the insured and align the agency and all the carriers that are in play.
And from a carrier standpoint or program standpoint, you get well-funded plaintiff lawyers funded by third-party litigation, and they're bringing in top-quality doctors to testify, top-quality forensic recreation experts. Laura, you deal with this all the time. From your vantage point, when they bring in these high-powered expert witnesses, how do you guys combat? Do you go out and bring your own high-powered experts in?
I think you have to be really thoughtful there and think about the case and do it on a case-by-case basis. There's certainly some jurisdictions, New York in particular, where they're looking for that battle of the experts. And if you have one high-flying expert on one side, you want to counter that with the same level on the other side. But then I actually find in different jurisdictions, Texas potentially being one of them, depending on the county, where a very expensive expert kind of plays like that. And pragmatists can see this is a hired gun. This person spent no time with the claimant. They never met them in person, or they met them one time. And then we really try to draw out testimony around how much were you compensated for your appearance in court today? And how much time did you spend with this person to give your opinion? And, in some jurisdictions that plays really well. So knowing your jury pool and what potentially resonates with them and making decisions accordingly is a big part of the strategy.
So your job is very, very mundane. Everything is the same day in and day out. I'm being very facetious. Laura, you're in a very exciting field of the claims management business. It's higher hazard, heavy construction type accounts, and you see it all. The pain right now is where rubber meets the road. Anything locomotion over the road, we get quick representation from plaintiff attorneys. We've talked about extensively on our podcast about case runners getting this information to a plaintiff lawyer within hours.
Yeah.
So your job's cut out.
I had one recently, just a few weeks ago, where an accident in Texas, and the other party got out of the vehicle, and before he called his family, before he called his wife, his kids, he had his attorney on the line. And so our customer, our insured, called me and said, hey, this is odd. There's a guy that is on the scene of the accident, and he has his cell phone to the ear of the police officer because he wants the police officer to talk to his attorney on the scene in hopes that somehow the attorney could maybe, talk to the police. And this gets into the police report or whatever. So we had to pivot and do the same thing. So our customer downloaded their dash cam video, texted it to the driver of our truck, and showed it to the police officer. And luckily, the police officer was really annoyed that the guy put his attorney on the phone and put it up to his ear. We have a pretty solid, case on that one. But yeah, it's like he didn't call for anybody else but his attorney at that moment. Just got in an accident, and he's like, plaintiff counsel, please help me in this situation. it's I don't know. It's crazy. That's a little quick, almost as if it was, maybe he was planning on it. I don't know. We'll see.
Well, video is a great truth teller.
Yes, it is.
So I want to move on to another topic. And we've talked about this too on our podcast, the borrowed servant doctrine. And there was a big case here in Texas back in 2019. A tower crane collapsed. Laura, I want to talk to you about, are you guys using borrowed servant for a defense on certain cases?
We are. So we actually are using borrowed servant in a couple different ways, factually in specific claims where it makes sense to do so. And we can talk about that more, but also at dual specialty construction and transport, we really have unprecedented loss control assistance for our policyholders. And so as part of our service, we will work with the policyholder to get their contracts set up so that they are in a great place to make borrowed servant arguments or protect themselves against borrowed servant arguments, depending upon the context of their work. And so that can be very helpful before a claim even originates, just going to market, knowing that you have your rental ticket or whatever your contracts are in order so that you're prepared to protect yourself in the event of a claim. So we're using it offensively and defensively.
You want to dig a little bit deeper in the woods and explain what borrowed servant is?
Absolutely. I actually was fortunate enough to just write an article about it in May for American Crane and Transport magazine. So I'm thankful to the SCNRA for that opportunity. But it's a legal concept, so try to bear with me. I know nobody wants to talk too much about legal things, but it really can be material for your loss run, so it is important. The concept is generally a basic one. You are an employee of one employer, the general employer, but you are, through any mechanism, working for another employer, the special employer, and the special employer controls how you do your work and what work you're doing. If something happens as a result of your work for the special employer may be responsible for the economic consequences of that instead of your general employer. So the key part of the analysis is control. Who was controlling your work at the time of an accident or whatever event took place causing damage?